Sorry for the long day. I'm sure you've had one too. This is item 36.
Been long for everybody, but thank you, Mr. Chair and members. I'll go ahead and start speaking while the witnesses are coming up.
And Senator Huff, I'm reminded that there's currently no opposition, so just as
I will try to keep it brief but make a compelling argument. I've already shortened my speech, you'll be pleased to know. 32% of all California drivers killed in motor vehicle crashes in 2013 who were tested positive for legal and or illegal drugs. National Highway Traffic Safety Administration study in 2014 found that in California alone, drivers killed in crashes that tested positive for drugs increased by 11%. The fact is, we have sadly become a self-medicating, careless culture. People think as long as they're not drunk behind the wheel, they can avoid scrutiny because we lack the same sort of roadside deterrence to detect drugs like we do alcohol. It's incumbent upon us to help law enforcement attain every tool necessary to get drug abusers off the road before more families are forever crushed by life-altering tragedy. SB 1462 will simply allow law enforcement to use oral fluid roadside tests as a screening device to detect drivers with active drugs in their system when there is probable cause that an officer suspects suspicious or reckless driving and the driver has already failed field sobriety tests. The handheld analyzer will, in about 5 minutes, detect the presence of 6 of the most common drugs of abuse at the time of a traffic stop. This is a minimally invasive test self-administered by the motorist. This is not brand new technology. The National Highway Traffic Safety Administration has been using these devices since 2007 in national roadside surveys and is now providing a grant funding for states who wish to purchase them. 15 states, including California's pilot program that ended in 2014, are using the oral fluid screening device. Oral fluid provides officers the opportunity to collect critical evidence close to the time of the initial contact when the objective signs of impairment are present. With this efficient roadside analyzer, officers can produce more meaningful impairment assessments and get drivers under the influence of drugs off the road or send motorists on their way. SB 1462 is sponsored by We Save Lives, California Narcotics Officers Association, and the California Police Chiefs. It's supported by numerous law enforcement organizations, Crime Victims United, and the Association of California Insurance Companies, representing 391 property casualty insurance companies in California. I would like to introduce Dominica Cardenas, whose father was killed by a drugged driver. She is an inspirational voice for We Save Lives.
welcome.
Thank you. Good afternoon, members of this committee. Thank you for allowing me to speak on behalf of my family about the horrible tragedy that took my father away from us and his friends less than 3 years ago. My name is Dominica Cardenas, and I am here on behalf of We Save Lives to talk about what drug driving has done to our lives. My dad, Juan Antonio Cardenas, was a victim of an impaired driver who made the choice to drive under the influence of drugs. This unfortunate and tragic event happened in Daly City, California on Memorial Weekend of 2013. To be exact, it happened on May 24, 2013. And that was the day that changed our lives forever. My dad, Juan Antonio Cardenas, was not only a father to 2 children, but a husband, a grandfather of 4 beautiful grandchildren, and a true and loyal friend to many extended family members and countless others who loved him as much as we did. On that fateful night of May 24, 2013, my dad was on his way to work when he started to cross the street at the intersection to catch his bus. The night of the crash, he was carrying a bag of fruit for his coworkers. The first car that approached the intersection stopped to let my dad to cross, but there was a car behind it, which pulled over to around the van that allowed my dad to cross when he just immediately hit him with a 2-ton weapon. He didn't brake and with the full force of his car crashed into my dad, causing major brain trauma. For 3 weeks, we stood vigil by his bed, praying he will survive. He never regained consciousness, and a day before Father's Day, my dad died. Police also found small amounts of meth in the offender's car and baggies for the drugs he was hiding. After 18 months and numerous court appearances, the jury found the offender guilty. This conviction is the offender's second strike on under the California three-strike law. He was previously convicted of felony drug sales. My mom is living a life sentence. Her soulmate is gone. She will never see her best friend, her protector, the love of her life ever again. As for myself, since the day I was born, my world revolved around my dad. I not only lost my dad, but I lost my best friend, my partner in crime. I lay my head down at night constantly thinking of my dad, crying and wishing this was just a nightmare. Our family has unwillingly joined a growing number of drug-driving victims and survivors because of a driver who made a deadly choice. This is not acceptable. This crime can be prevented. It can be stopped. I am asking on behalf of my family and We Save Lives to support SB 1462 so that others may be spared our pain and loss. Thank you.
Next speaker is Gail Randall, the mother of Harrison Long Randall. Her son Harrison was 21 years old when he was hit by a man in a drug-induced stupor nearly 4 years ago.
Good afternoon, members of the committee. My name is Gail Randall, and today I'm here to address the committee about Senate Bill 1462 and the importance of this bill. I'd like to thank Senator Huff for carrying this legislation. Thank you. My son, Harrison Blake Long Randall, was the victim of a driver who, more likely than not, was under the influence of heroin at the time he was hit while walking home from an evening walk on July 16, 2012. The accident started out as a hit and run, and he was hit so hard it amputated his right leg at the knee and sent him flying 65 feet from the point of impact. The perpetrator was finally apprehended 3 days later with trace amounts of Xanax and other drugs in his system. The individual had a known drug history, and while he was convicted of second-degree murder, evidence at the trial showed this was not his first drug-related offense. Drug-related collision. The burden of our prosecutors to prove these cases on driving under the influence of drugs is extremely difficult due to the lack of evidence they are able to collect at the time a traffic stop is performed. We have already developed tests which detect alcohol levels in a driver, and technology is beginning to catch up and to provide similar tests for detection of illegal drugs. It is a travesty that so many people every year die or are injured because we fail to provide our law enforcement and prosecutors adequate technology to stem the rising tide of drug-related impaired drivers. I live with the knowledge every day of my life since the death of my son, and know that we as citizens and legislators do not do something to curb drug DUIs, the problem will only continue to escalate. I refuse to sit back and not do something and let more people get killed and injured for my son's death to be in vain. So I implore you, please move this bill forward. Thank you.
Thank you very much. Are there any other witnesses in favor? Any witnesses in opposition?
Mr. Chair, I do have a
Yeah.
couple more that are trying to get their way up here.
Yeah, a few more in support.
Dr. Christine Moore is a member of the National Safety Council's Alcohol, Drugs, and Impairment Division. Dr. Moore is the Vice President of Toxicology Research and Development for Immunolysis Corporation. She currently has 110 peer-reviewed publications regarding the analysis of drugs in various biological samples, including blood and oral fluid. And after her, I have Brian Schaffer with Draeger Safety Diagnostics, who can answer any questions you have about the device. He is an expert witness in a case in Kern County. Then also just available to answer questions is Richard Desmond with the California Highway Patrol, who can address any issues you might have about what happens when an officer pulls over somebody they believe is driving impaired.
Thank you. Certainly appreciate your time. I'm speaking in support of SB 1462 and in support of law enforcement officers to use oral fluid for preliminary drug screening in drivers. Testing drugs in oral fluid is not a new concept. It is currently extensively implemented in many areas of toxicology, including workplace drug testing, pain management, rehabilitation programs, and criminal justice. Many other countries already use oral fluid for testing drivers for drugs, for recently using drugs. As Senator Huff mentioned, in 2007, the national survey, which was carried out by NHTSA, collected both oral fluid and blood from the same drivers at the same time. The correlation between those two types was over 97% when drugs were present, indicating oral fluid analysis provides similar information to blood. However, it has distinct advantages over blood in several areas. It's more convenient, easier and faster to collect, not invasive, does not require medically trained personnel, but perhaps most significantly can be collected proximate to the traffic stop, thereby minimizing that time delay associated with blood collection, time during which drugs, especially marijuana, dissipate very quickly from the system. In contrast to urine, both oral fluid and blood provide information regarding recent drug intake and not a historical window of detection. While it is true that THC can stay in the body of chronic marijuana users for several days after their last use, that intake will not be detected by blood or oral fluid at typical testing levels. Law enforcement officers can be confident that positive oral fluid tests are not indicative of historical cannabis use, but of a very recent episode. The preliminary devices do not detect every drug available, that's true, but they do identify the main classes of illicit compounds, including marijuana, cocaine, and amphetamines, including methamphetamine. Data from the California Office of Traffic Safety shows their reliability as a preliminary result, which, if positive, should be confirmed by a second test.
You can just sum up. I think if there's questions, I'm happy to come back
and
to
there
you.
you go. I urge the committee to approve
All
this
right,
legislation.
thank you very much.
Thank
And
you.
again, I think if there's questions that, you certainly have wonderful experts here that they could answer them, and maybe we could see if there is any. Can I just ask if there's some Me Too's and in favor? Go ahead and identify yourself.
Yeah, I'm Brian Schaffer from Drager Safety Diagnostics, and I'm here to answer any questions. We are a provider of some of these oral fluid technologies.
Fantastic, thank you. Are there other witnesses in favor? Please, I want to keep this moving.
Yeah. Chair and members, Jonathan Feldman with the California Police Chiefs Association, proud to be a co-sponsor.
Very good.
John Lovell, California Narcotic Officers Association, proud to co-sponsor and to me too.
Great, fantastic. Any other witnesses in favor? Very good. Any witnesses in opposition? All right, not seeing any comments from the panel. Yes, Senator Stone.
Thank you, Mr. Chairman. I applaud Senator Huff for bringing this forward, and my condolences to the families that had to come forward. Heartbreaking stories. This is a very simple test that can provide law enforcement officers the tools necessary to take people off the road that are under the influence of alcohol or drugs. And with that, I'll move the bill.
All right. Senator Huff, would you like to close?
I think we've heard a lot of testimony here. You don't have questions. I would ask for your aye vote.
Very good. I would join with Senator Stone in thanking Ms. Randall for coming and testifying and speaking of her son, Harrison, and Ms. Cardenas for coming and giving such articulate testimony on behalf of her father. I know that they would all be very proud of you today for taking that courageous step to share your story with us, and it was very, very powerful. With that, I understand there may be some technical amendments. Senator Huff, did you want to accept those?
Correct, the ones that were raised by the committee analysis.
I think it's just the one that deletes the reference to minors driving with alcohol, the 23-140. We already submitted that to the committee. Yeah, it's not in the bill yet, though.
Yeah, it's been we will take that at the next step. Thank you.
We'll take that at the next step?
No, we'll take it here.
We're taking it we're taking it here. Okay. So we have a motion with that technical amendment, if we could call the roll.
Hancock, Anderson, Glazer.
Aye.
Glazer, aye. Leno, Lou, Monning, Stone.
Aye.
Stone, aye.
All right, we're going to put that on call since there's some absent members. We're sorry that they're all not here, but they're all double booked, as we know, in this busy time. Thank you all very much. Thank you, Senator Huff.
Item 13.
We're going to go to item 13. That's SB 1080 by Senator Morell.
You ready,
Senator,
sir?
yes, we're ready. Thank you for being here. Sorry for the wait.
Not a problem, Mr. Chair. Thank you, and thank you, members. I would like to open in by accepting the committee amendments to clarify when malice should and should not be applied. Also to clarify that an individual is guilty of accepting stolen property under this section, and if they knew or should have known that it belonged to a veteran. I would also like to thank the committee and your staff for their time and consideration of this bill. SB 1080 holds individuals who vandalize the grave sites or memorials of veterans or first responders to greater accountability for their crime. The bill would make it a crime to damage, deface, destroy, or mutilate or remove veterans' grave markers or memorials from the grave of a veteran or first responder. The offense would be punishable by jail time not exceeding a year or up to a $5,000 fine. Veterans, peace officers, firefighters, and other first responders risk their lives to protect our communities and are held in high regard, and vandalism of their memorials has a significant impact on our communities, with the recent example when the Mexican-American Veterans Memorial here in Capitol Park was vandalized last summer. The statue was commissioned by a group of Mexican-American mothers whose sons died during World War II. They raised money by selling tamales and other food that they had made. Vandals broke the granite nose off the soldier's rifle, no small feat, as the vandals would have had to climb about 10 feet to reach it. And we've seen a number of cases recently, even one right here in Stockton just last week. Vandalism of any grave of a veteran is beyond reproach. Law enforcement needs a tool to penalize and track these individuals. By creating a separate code, SB 1080 would allow law enforcement to track any patterns of vandalism, targeting, and desecrating the memories of American heroes. Additionally, SB 1080 would consolidate pertinent code sections clearly outlining the crime and penalty. Members, we have a duty to preserve tributes to our men and women in uniform who put everything on the line for our safety and for our country. I am committed to working with the committee to move this bill forward, which would conveniently provide an opportunity to add co-authors. With me today is Pete Conity on behalf of the American GI Forum and other veterans group to discuss more about the importance of this bill. Thank you, members.
Thank you. Witnesses in favor?
Mr. Chairman, members, Pete Conity, representing the sponsor, and 20 other veterans groups were in support. This bill actually had its genesis, a series of bills that were passed in the state of Massachusetts, not exactly a really conservative state, but they felt it was necessary to protect our memorials and markers to our veterans and our first responders. Thank you.
Thank you.
John Lovell on behalf of the Association for Los Angeles Deputy Sheriffs, Association of Deputy District Attorneys, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, California Narcotic Officers Association, Los Angeles County Professional Peace Officers Association, Los Angeles Police Protective League, and Riverside Sheriffs Association, all in strong support.
Very good. Are there other witnesses in favor? All right, we'll go to witnesses in opposition. If you make room at the table, that'd be great. Okay.
Natasha Minsker, ACLU of California. Respectfully, we are opposed. The damage of any memorial or grave is reproachable conduct, and it is appropriately punished under California's criminal law. In fact, the conduct described here is already punished under several different statutes in California's criminal law. This bill is an example of the type of bill Governor Brown cautioned against last fall in his veto message. It recriminalizes conduct that is already criminalized, and it further complicates our sentencing laws without providing additional public safety benefit. We urge you to vote no. Thank you.
Very good. Any other witnesses in opposition? All right, seeing none, we'll bring the matter back to the committee. I would like to ask, since we're accepting some amendments, to have them put on the record so we can be clear about what they were. Yeah.
All right. The way the bill is drafted now, it's not clear that the element of malice applies to vandalism and desecrating graves. That's a standard element with these kind of crimes. But it does appear that malice applies to receiving stolen property, which would never be an element of receiving stolen property. So it would clarify that malice applies to the vandalism and desecration of graves crime. And as to all the crimes, because this is a special status, a veteran status, it would require that the defendant knew or should have known that the memorial or marker was to a veteran or a police officer or firefighter.
Very good. Senator Stone, you have comments on this?
Yeah, thank you, Mr. Chair. I would be honored to be a co-author of the bill. I appreciate you bringing it forward, and in the honor of all of our firefighters and veterans and police officers and those in public service that have given the ultimate sacrifice and have served the state and this country. I move the bill.
Thank you.
Very good. And Senator Morell, I would also ask to be listed as a co-author if that is appropriate. And with that,
Thank you
would
very
like to
much, by the
close?
way. Thank you. Yeah, I just respectfully ask for your aye vote and grateful for your co-author.
Great. Thank you very much. So with that, we'll ask for the roll to be taken.
Hancock, Anderson, Glazer.
Aye.
Glazer, aye. Leno, Lou, Monning, Stone.
Aye.
Stone, aye.
All right, that bill will remain on call as we wait for the other members to join us. Thank you very much.
Thank you very much.
Okay, we're going to go to SB 1419 by Senator Galgiani. Welcome.
Thank you, Mr. Chair and members. SB 1419 would authorize a prisoner in the custody of the Department of Corrections and Rehabilitation to elect to make an anatomical gift included on the intake form. The bill would authorize the prisoner to make that election at the time of admittance into the state prison system or at a later time at the prisoner's request. The bill would establish a procedure by which a prisoner may revoke that election as well. The United States is currently facing a shortage of anatomical gift donors, with California making up to 20% of the national donor waiting list. Additionally, less than 1% of hospital deaths meet the criteria for organ donation. It is estimated that one individual organ donor can save the lives of up to 8 people, and tissue donors can help more than 50 people. Due to the fact that there is no process in place to provide inmates with the chance to donate, potential donors are prevented from registering. This bill will create a voluntary process for an inmate to register as an organ donor, which could increase the donor pool. In Utah, where similar legislation allowing for voluntary sign-up has been enacted, over 250 inmates have already voluntarily signed up. In addition, I would like to make note of the amendments we took to address any concerns of coercion or retaliation. I respectfully ask for your aye vote.
Thank you. Are there speakers in support of the bill?
John Lovell on behalf of the California Correctional Supervisors Organization in support.
Thank you. Others? Are there speakers in opposition to the bill? Seeing and hearing none, Senator Stone.
Thank you, Madam Chairwoman. I just want to thank the author for bringing this forward. I'd love to be a co-author with you. I think it's a very thoughtful bill, and I'd like to move it.
Thank you very much.
Hey, I agree. It's a very good bill, Senator. Is there a motion on the bill?
Yes, I made it.
Oh, you made it. I'm sorry. Missed that. And would you like to close?
I respectfully ask for your aye vote and thank you for working with me on the bill.
Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Glazer.
Aye.
Glazer, aye. Leno, Lou, Monning, Stone.
Aye.
Stone, aye.
3 ayes. We'll hold the roll open for the absent members. And Senator Glazer, I think you had another bill?
Yes.
At least one? Yeah.
Lost the, who am I looking at? All right. Madam Chair, wherever you are. Good afternoon, members. Today I'm presenting SB 1311, a bill relating to license plate confidentiality. I'd like to start by thanking the chair and the committee staff for allowing me to take amendments to this bill today. I think they're before you. Certain individuals who fall into a designated employment class, such as judges, public sector attorneys, peace officers, local elected officials, and their spouses and children, have their home addresses shielded from inspection for their own protection. This shielding of information occurs when a peace officer queries the DMV database for information by running a person's license plate. As amended, SB 1311 will simply remove from this database any spouse or child that's been convicted of a felony. This will take away that confidentiality protection and will provide enhanced protection and safety for our peace officers. These amendments remove all known opposition. I respectfully ask for an aye vote.
Thank you.
Madam Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association, the sponsors of the bill. I'd like to thank the committee and our prior committee, Senate Transportation Committee, also worked with the opponents, with law enforcement labor, had some concerns about the bill. We worked on it with the author and his staff. We come up with a compromise that I think satisfies everyone. Basically what the amendments do that were agreed to in the Transportation Committee, but were not taken in the interest of time, given the double referral to this committee. The amendments that were agreed upon would basically strike the contents of the bill and limit the measure to simply say that a spouse or a child of a person who has confidentiality under this section would be removed if they're convicted of a felony. So not any low-level crime, and it's similar to the provision that currently exists that when an employee, one of the 23-member employee classes that currently enjoys this protection, that if they're convicted of a crime, they may be removed from the database. We took a step further and said felony for a child or a spouse, since there is no mechanism to get rid of that person from this list. So in the interest of time, we'd simply ask for your aye vote. Happy to answer any questions.
Thank you. Are there others in support? Is there opposition to the bill? Seeing and hearing none, Senator Glazer, would you like to close?
Respectfully ask for an aye vote, and thank you to the Sheriff's Association for their leadership in this, and to your committee staff for your help.
Thank you. Well, the bill has been moved, and we'll call the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Glazer. Aye. Glazer, aye. Leno. Liu. Monning. Stone.
Okay. Thank you. Well, Senator Stone, I believe you have a bill?
Yes, Madam Chair.
Yeah. And if the sergeants could just let some of the absent members know that we're almost ready for them to present.
Good afternoon, Madam Chair, members. I know it's been a long day. I appreciate all of your patience and deliberations today. Madam Chairwoman and members, SB 1321 is a simple solution to a problem that's been plaguing not just my district, but all of California. Recently, parts of Riverside County, specifically the Coachella Valley, has experienced an uptick in crime. Robbery is up 3.2%. Aggravated assaults are up by 8.3%. And alarmingly, vehicle theft is up 14.1%, and larceny is up 10.5%. The split sentence situation created in 2011 has led to what have some described as a revolving door, whereby individuals receive a sentence that includes mandatory supervision, which is just serving your sentence but outside of jail. It is our belief that the revolving door of mandatory supervision has contributed to this increase in crime. SB 1321 would mandate that a felony offense committed by an individual on mandatory supervision would lead to their second sentence being served in state prison. The Riverside County Probation Department notes since 2012, 980 defendants actively being supervised on mandatory supervision obtained a new mandatory supervision case referral within 30 days or more of their original supervision start date. Since all of these new cases were mandatory supervision referrals, they were all felony offense levels. Allow me to be clear. This bill is not designed to send people to prison for technical violations committed while on mandatory supervision. It is meant to aid our local law enforcement and strengthen our commitment to public safety by making sure that individuals who reoffend while on mandatory supervision with a bona fide felony will be sent to prison if they offend. Thank you for your time, and I would appreciate an A vote.
Are there speakers in support of the bill?
Madam Chair, members, Marty Veronica on behalf of the California District Attorneys Association. We were a little late in getting a support letter in before the analysis, but I want to indicate that we are fully in support of this measure. Thank you.
All right, any other witnesses in favor?
Mr. Chair, members, of course, use this one. Mr. Chair and members, Corey Salzillo on behalf of the California State Sheriff's Association in support of the bill. Current law permits enhanced penalties when a person commits a new offense while they're out on bail, and rules of court specify that a crime committed while on probation or parole can be deemed an aggravating factor at sentencing. So in the spirit of those provisions, we think this is appropriate and would ask for your aye vote.
Any other witnesses in favor? Any witnesses in opposition?
Natasha Minsker, ACLU of California. Respectfully, we are opposed. There are two core concepts to realignment. One is that our state prison beds are limited commodities, limited resources that should be best used for people who commit violent offenses. And two, that for people who are going to return to the community, rehabilitation should be the focus, and rehabilitation is best achieved when people are kept close to home to serve their time, where they can maintain ties to the community and family visits and transition into post-custodial supervision services. This bill is contrary to both of those core concepts of realignment, and it would, in fact, result in, again, overcrowding in our state prisons and limit our ability to actually use those prison beds for the people that the voters think are most appropriate, including people who have committed serious and violent offenses. We urge your no vote. Thank you.
Khalif Asagay on behalf of the California Public Defenders Association, also in strong opposition to this measure. I'll align my comments with those of my colleague and also add that California should not regress to a sentencing system that once again requires a person who commits low-level felonies to be sent to state prison. State prison should continue to be reserved for serious and violent felons and sex offender statutes. Statute after statute states the goal of AB 109 and the recent Proposition 47 to reduce this population, and therefore we should continue sending these people to county jail and not to state prison.
And any other witnesses in opposition?
Brittany Stonecipher from Legal Services for Prisoners with Children in strong opposition.
All right, seeing no further witnesses in opposition, we'll close the matter there, bring it back to the committee for comments or questions.
I
All right,
have no
Senators-
comments or questions. I
Senator
do
Stone?
agree with the opposition that we're not sending people back to state prison right now.
Okay, very good. Senator Stone, would you like to close?
Thank you, Mr. Chairman. I have developed a close relationship with a number of district attorneys in Riverside County, and I can tell you that I'll give you the example of auto theft. Auto theft, they get caught, they get sent to county jail, they go on a split sentence, and then they go steal another car, and they get back into the county jail through the revolving door. They don't serve all their time, as you know, in the county jails, which are also congested. Meanwhile, there is capacity in the state prison, and what we see is just a revolving door of justice in our county, and I believe it's happening in other counties as well. There has to be consequences to crimes. You just can't continue to let people go. And in fact, one of the persons that was stealing cars actually said to a district attorney, this is a situation where crime pays. Because I go out and steal 3 or 4 cars before I get caught again, and I just go back into the county jail, go on and split sentence, and I'm back out in the community again, committing my bad deeds. So I appreciate that we don't want to fill up our state prisons, but I think we've done a pretty good job of emptying our state prisons, and we need to hold people accountable for their crimes. And the statistics are up, including violent crime. And so I would hope that you would join me in supporting this. I urge and I vote.
Thank you very much, Senator Stone, for your close. We're all set for a roll. Is there a motion? Is there a motion on this bill? I'll move the bill as a courtesy. Call the roll.
Hancock? No. Hancock, no. Anderson? Glazer?
Aye.
Glazer, aye. Leno? Lou? Monning? Stone?
Aye, thank you.
Stone,
Put
aye.
that bill on call and wait for the other members to join us.
Thank you, Mr. Chairman.
Where do we go next? Senator Hancock, welcome. We haven't seen you all day. What bill number?
1070.
This is SB 1070, which is file item 12.